finished going through schedule 2, or the second schedule rather, and we are to pick up on schedule 3 today. And then we'll have the opportunity to revisit some of the items that we had would have required a little more deliberation, and we had grouped them together to address them towards the end. So before moving into the meat of the matter and before looking at the minutes, I would just ask Dr. Dunn if he could open in a word of prayer.
Thank you very much, Chairman. Let us pray. Almighty God, our Heavenly Father, we thank you for this day and the opportunity to be here. We thank you for the opportunity to meet in this fashion. Though we are not physically together, we're still able to speak to each other. And as we deal with these very important and critical areas of the BRA, the custom of Jamaica, we pray, dear Lord, that as we deliberate on the matters, we will ensure that we do so in a respectful manner, but also in a diligent manner, so that the decisions that we arrive at will be to the benefit of all of Jamaica. Thank you very much. In Jesus' name I pray, amen.
Amen. Thank you, Minister Dunn. Okay, do we have any apologies for absence?
Yes, Chairman, we have an apology from Senator Hill. There's also an apology from Miss Judith Grant. She'll be absent today, but will be represented by Mrs. Douglas Sherland.
Okay. All right, the minutes of the last meeting have been circulated. That's the minutes of the meeting of the 15th of July. And I just want to know if there are any amendments to the minutes prior to the move for confirmation. Any amendments to pages 1 or 2? Pages 3 or 4? 5 or 6? Seven or 8?
Yes, good afternoon, Chairman. Just 2 comments on page 8. The first one is at the paragraph referring to part 8, goods imported for meetings, incentives, conventions, or expositions. At the second line, we see that reference to my space.
No, not my, yes, that's correct.
Right, so let's correct that. And that really would be the MICE, MICE, which is really just the abbreviation for meetings, incentives, conventions, and expositions.
Yeah, it's capital M, capital I, capital C, capital E.
Yes.
Yes. Capital M dot, capital I dot, capital C dot, capital E.
Right, which is really just the meetings, incentives, conventions, or expositions.
Thank you for catching that.
Yes, and then one other adjustment under the paragraph beginning, subheading second schedule, the second paragraph, the last sentence. She stated that that had been introduced as new language in the second schedule. I'm not sure if that's what I said, but if I did, then I misspoke. It is to be introduced. So the second schedule would not have the language as yet in terms of the bill that was tabled, because that the decision to make the adjustment to treat with the World Trade Organization Decision 6.1 arose from the comments of the Revenue Appeals Division that they made after the bill had been tabled. So perhaps if we just adjust that to this, she stated that is to be introduced as new language in the second schedule.
Thank you for that. All right, for pages 8 and 9 with those proposed amendments. All in favor, can I have someone to move for confirmation of the minutes? I see Senator Allen.
Yes.
And
I so move.
seconded by Minister Dunn.
Yes, Chairman.
Okay, wonderful. Thank you. So let us now resume on with the review of the I think it's the third and the fourth schedule. And anybody has a page number, whoever gets there first, just shout out the page number if you don't mind. Page
835.
Yeah, let me look. Right, 835. Okay, wonderful. Thank you, Mr. Foreman. All right, so the third schedule, page 835, is before us. Now, does this schedule reflect the existing? No, it doesn't, because we have new offenses, do we?
Right, so both the third and fourth schedules are new schedules to the Act. Some of the offenses reflected there are no offenses in the current Act, but in some instances, there are some new offenses. And of course, it's presented differently.
Okay, and would you be able to point out the new ones?
Minister, the thing is that even where the offense, even where the third schedule, for example, introduces an offense that, is a current offense, the penalty in almost all instances, in fact, I dare say all of the instances, the penalty has changed.
Right. So, okay.
Right.
So you want to talk about the philosophy behind the penalty regime that you have in place?
Right. So in relation to the third schedule, this is the list of offenses that, if committed, would attract prosecution. So there is no option for an administrative settlement of the offenses listed in the third schedule. You will notice, therefore, that it's a very short schedule. And the idea there is that the majority of the offenses under the Customs Act should be open to administrative settlement. And so the ones that are listed in the third schedule are those that are regarded as sufficiently serious and grave.
Understood.
And would have a negative impact on customs.
Okay.
There was also.
Do we want to do this? We're going to read these word for word, or is that necessary? Can we just go page by page?
Minister?
Yes, Minister. Yes, Member Hilton.
I think where we can be helped is, as you have asked at the beginning, sort of to give us a feel for the underlying considerations that inform, especially since the third schedule we're being advised is the only schedule that does not allow for administrative remedy. What guides that? What is the legislative intent and the philosophy behind it? That will be helpful to us in whether we even go in the details that, as you asked, but I think we need some guidance.
Yeah, I think what she's saying is that these are serious offenses of fraud.
What makes them serious though?
Yeah, so that's why it's short. That administrative ones have been carved out. If you look at them, so let's go. 840, page 835. A person knowingly imports or into Jamaica or harbors, conceals any prohibited goods or restricted goods, which are, contraband. Knowingly harbors or conceals any goods on which custom duty is liable to be paid, or imports or exports. Any comments on page 835?
Just make an observation.
When you say, for example, knowingly, well, I think the knowingly there makes a big difference, because it could be questionable at times whether customs duty, there could be genuine differences as to classification and all of that. So, but the knowingly, I think, qualifies it and puts it in a different rank. So, all right, maybe we should just run through them, Minister, since it's short, and then.
Yes. So I'm just going to page by 835, and I give a minute or so for you everybody to read.
Minister, if I may just make one observation. When we were looking at it, we noted that the words or restricting should be introduced at 1A. So the provision should read, knowingly imports into Jamaica or harbors or conceals any prohibited goods or restricted goods in contravention of the provisions of this act or any other law prohibiting or restricting the importation of those goods. So the words or restricting were inadvertently left out.
Okay, fair enough.
I'm also, I believe, duty bound, Minister, to point out that in relation to the third schedule, one of the concerns that Stakeholder had raised is in terms of whether the sanctions that are now being proposed for these matters, whether the sanctions are too severe. And so that's something that we certainly want the committee to look at, obviously. The technical
clearly, that's something that we'll be looking at as we go through.
The sanctions.
On the first page, I don't think so for what you have, the offenses that you have on the first page. I don't know what other views are. If there are no comments on 835, what about 836? Impersonating an officer. Somebody who gets into the customs system. On page 837, obstructing or failing to comply with an officer. Breaching confidentiality is a big deal. Right, so the obstructing an officer that arises in relation to 275 subsection 2, which is obstructing, is not just obstructing an officer, it's obstructing an officer who is performing an enforcement function or fails to comply with a lawful request of the officer made in the performance of such function. Okay, so that's page 837. Page 838, dealing with offenses without reasonable excuse, entering or refusing to leave a custom control area.
Just note, Minister, that we're now in the fourth schedule.
Well, that's the fourth now. The third is right. That's why you said the third was brief. You're absolutely correct. Right.
Yes,
the third
it's quite
is brief, is dealing with major issues. So everything else is administrative.
Yes, everything else it's possible for a person to settle the matter administratively, right. Possible to avoid prosecution.
Right. But these 6 offenses are rise to the level that there's no discretion. And I think we can understand why. All right, so that's the third schedule, members. The fourth schedule now has offenses to which discretion can be used to apply an administrative penalty. And the administrative penalty is the penalty listed in column 2, or that would be for customs to determine it. The idea here is that if you can discharge the offense by paying the administrative penalty that's listed in column 2, is that it?
Yes, and that is the maximum penalty.
The maximum penalty. Okay.
Yes.
All right. So let's go through these in the same way. On the fourth schedule, first page, without reasonable excuse, entering or refusing to leave a customs control area. And the second offense is an offense of concealing goods under the customs control in a manner calculated to deceive the commissioner. What does, in the second column, you have a fine not exceeding blank? Oh, not exceeding whichever is the greater of. Okay, sorry.
Chairman.
Yes.
On on the fine, the column 2, the penalty. On the second part, it says on 2A, 3 million. Why aren't we consistent in the fines?
No, it's just saying not exceeding, whichever is greater. So, when you say consistent, what do you mean?
So we've been using like in the third schedule, most of it was 5 million, and in the fourth schedule, which is concealing goods under custom control, which is to deceive the commissioner.
Right.
It's the fines before for persons who are either impersonated or commit offense in obstruction, etc., etc. It's $5 million.
Yeah.
And we are here now doing $3 million. Why? Just want to know, Ms. Edwards, was there thought behind it?
It was really a judgment call based on what was viewed as being more severe. And so, for example, if you're impersonating an officer, there's no question of the negative effect on the agency, as well as the deliberate nature of such, conduct. There's clearly mens rea there, whereas you may have a scenario where goods are concealed, but it may not rise to that level. And so the feeling was that the maximum $3 million was an appropriate maximum threshold for the concealing offense, and $5 million was the appropriate threshold for the impersonating the officer offense.
I agree.
All right, thank you. Thank you.
All right, page 839, without lawful excuse, tampering or interfering with or destroying goods under customs control. And the fact that can be dealt with administratively, definitely showing some flexibility. But even though it has a 3 million there, it's a greater of the maximum is a greater of that and 3 times the value of the goods. On page 840, without reasonable excuse, removing, damaging, or tampering or interfering with anything, knowing or having reasonable cause to know that the thing is in use by or for the use of the customs agency. That's tampering with their property. And then without lawful excuse, interfering with or taking possession of any goods prohibited from importation or exportation under any law and under customs control. And then 841, embezzling or misappropriating or unlawfully removing, converting, or destroying goods deposited in any customs control area, contrary to section 39.
And notice for that one, that was judged as sufficiently serious. So you notice that the threshold there, the maximum threshold there is that $5 million or that greater figure.
Right. Yes, noted.
And on page 842, an offense under section 41.5 of unloading, removing, or transferring goods contrary to the provisions of that section. And just to jog the memory. This is 41.5 that with foreign going vessels or foreign going aircraft. All right, 843 has a number of offenses here. And these really speak to I guess the companies involved in bringing people and goods. If vessels or aircraft depart without permission or fail to provide passenger information or advance arrival information, or to submit report of arrival, etc., etc. Just some dollar fines between $1 and $3 million as the maximum. Page 844. Failure to give notification under 79, failure of the transfer of ownership of goods, failure to transport goods that are not in free circulation, failure to report breakdown accident, failure to comply with the offloading or loading requirements, commencing transport of customs control area goods before they're released. Page 845, failure to comply with provisions 93.2, 3, 4, and 6, and 93.2 deals with the transportation of goods that are under customs control. 95.1 deals with goods that permission for goods to be transferred for transshipment. Okay, and 21 deals with an offense under 97.4, which is when goods are released to the custody of a person. All right, that's 845. Moving on to 846, which has one offense, an offense under section 99.4 or failure to comply. 99.4 deals with a warehouse keeper. Oh, about goods in warehouses. Goods to be warehoused in import packaging. And then 847 lists a number of offenses, which it might not make sense to read all of them. 848 has 3, removal of stores from a vessel, delivering goods to a place of export, failure to notify the commissioner. And then page 849 deals with a number, about 9 offenses, failure of the declarant to keep records as required, which is a big deal. And a number of others. That's 849.
Chairman, one moment.
Yes, go ahead.
Just for my my naivety, Ms. Edwards, removal of stores. So stores is defined in the definitions, or it is already understood what it is. Just I mean, I'm naive to it.
Right, so there is a stores procedure that is provided for in the act. So we would have gone through that. It has to do essentially with items that are provided for foreign going vessels and aircraft. So they may take on board food items for use during the voyage and so on.
Okay, great. Thank you.
Okay, so 848 and 849 is what we were on. $850. $851. Right, that would conclude the 4th schedule. Do we normally review the memorandum of objects and reasons as well? And if that is in order, then we could turn our attention to the task of addressing the number of matters that we had deferred for further deliberation and discussion. And I will just begin by referring to the matter and seeing if I can rejog memories, and then we can ensue in a discussion and hopefully arrive at a a conclusion and where we can guide the drafters as to the thinking of the committee. Now, some of the issues are, much simpler than others, and if they don't warrant a long conversation, then I would ask that we just are able to move on with them. But those that require some discussion, definitely we will allot whatever time is required to hash those out. So the first matter that we had agreed to defer was whether in clause 2, the definition of clearance on page 3, whether the word "the" should come before the word goods, whether that should be deleted. So clearance is defined as in relation to goods, means the accomplishment of the requirements necessary under the customs laws to allow the goods to be placed under a customs procedure, whether that "the" should be deleted. And we had said the proposed amendment we'd agreed to, subject to the advice of the CPC. I don't know what, she's not here today. But I think we're happy with that, subject to her advice that doesn't change any meaning. If we could move on to the second one, and let me give you an idea. We have
Chairman, before you move on.
Go ahead, please. We have 35 items that we had deferred.
Yeah.
Or more, actually.
Yeah.
36. Yeah, go ahead, Member Hilton.
Yeah, I think as simple as this sound, we really need to get it right, because it really has to do with the speed at which the need for a sort of clear, definitive approach, a sort of black line approach, because that will have, in its operations, really will make the difference between the speed at which you're able to clear goods and to really avoid penalties in many instances. So if I understand it, the CPC is not here, but if someone from our office, could we just have the comments from someone from our office?
Good afternoon, everybody.
Good afternoon.
This is Dawn Douglas Sherland, but I would kindly ask the chairman to repeat where was it where was it said that they should be deleted, from which definition?
From the definition of clearance.
Okay. So after means accomplishment of the requirements? Is it that?
No, clearance.
Clearance in relation to
Clearance on
goods.
page 3.
Yes, clearance in
So
relation to goods means the accomplishment of the requirements necessary under the
Custom laws to allow the goods.
Okay. It appears that they could be deleted.
But Chairman, why?
Or, well,
the good would refer
or
to
not, because they would qualify the goods that came before. So in relation to goods, and then when goods is mentioned on the second occasion, it's referring to the goods that were mentioned before. So they could be retained. But of course, I can draw the CPC's attention to it once more so that it can be finally decided what is the better approach.
Are you happy with that, Member Hilton?
my sense is that it should be retained because it qualified, having spoken to goods before, it qualifies the cleared goods, the goods that are in fact cleared. The other concern, the related concern that I have is when you have clearance, my understanding is that you still are subject to under a customs proceeding. And it is perhaps we're headed in that direction to clarify that, because when you say clearance, a good is cleared. In the normal parlance, when someone said they cleared goods, you really mean you're physically clear customs and done with customs proceedings. That's the sort of generic understanding. Now, to the extent that this isn't in line with what is widely understood in the common parlance, there could be opportunity for misunderstanding, and so if legally it's not aligned with the common understanding, we need to be very, very clear. So my understanding is that clearance is just one of the steps in this process within customs procedures. But I'd like a technical person to comment on, maybe someone from customs to comment on this journey, so to speak, of when goods are actually cleared or still under custom procedures.
But Chairman, if I may say something, but the thing to remember, Hilton, is that this is, while the common parlance might be that, this
Go ahead, I'm listening.
Hilton?
Yes.
Hello?
Yes, I'm listening. I'm listening.
No, someone's going with the microphone there. Ms. Edwards, you wanted to respond to Mr. Hilton's request for a flow?
I'm not hearing anybody.
Yes, I could, even though I'm hearing Member Dunn, but I'm not sure. He doesn't seem to be hearing us. But to answer you, Member Hilton, the term clearance here is not being used in the ordinary way in which you may be contemplating it. What it is simply is clearance is all the actions taken by an importer or an exporter in order to bring goods under a customs procedure. So you may be clearing goods for the warehousing procedure. When you have done everything that is required to bring those goods under warehousing, then you would say you've cleared the goods. But it doesn't mean that you're finished with customs, because the nature of the warehousing procedure is such that those goods are still under customs control, and you may still have to engage with customs in relation to those goods. But you would have done everything required to bring those goods under the warehousing procedure. You may have a home use scenario, which tends to be the scenario that many of us encounter, which is that we have cleared goods for our own personal use. And in that case, we have brought those goods under the home use customs procedure, right? Now, provided that there are no restrictions related to those goods under the home use procedure, then at that point, you could say you're done with customs, right? But clearance doesn't necessarily mean that you have no further engagement with customs. What clearance means is that you've done everything required to cause the goods to be treated in the way in which you've asked customs to treat those goods, pursuant to whatever type of goods declaration you had submitted.
Ms. Edwards, could I also add that even when you clear for the home use, if you're a company, you are still required under law to keep certain records, so you will still possibly have some interaction with customs.
Correct.
Indeed, you may. And a classic case of a home use, of clearing goods for home use, but still having an engagement with customs would be, for example, persons who are motor vehicle concession holders. right? So the motor vehicle has been brought under the home use procedure. You're entitled to drive it and enjoy it. But there are certain restrictions that apply, which is that you would have enjoyed a 20% duty concession, and you are required to keep the motor vehicle for at least 3 years. If you sell the motor vehicle or part with it before the 3 years expires, unless you obtain some sort of waiver or other approval from the Minister of Finance, then customs will demand the duties from you. So you're under the home use procedure, but you still have to engage with customs in relation to the goods.
This doesn't need to detain us here, but just to...
I was just going to say, I mean, it's the word the.
Yeah, no, it doesn't need to be... Yeah, but it doesn't need, well, you know, sometimes a comma is the source of quite a bit of conversation. But in this case, Minister, we don't need to be detained by it. What I think would suffice is that I contemplate that when this is done, that we'll have some sort of education around it, some kind of public discussion, so that stakeholders, which are not just the experts, the custom brokers and the freight forwarders and the professionals who deal with, but that the public at large can have a feel for whatever the changes may be. And they may not be big changes, but I think there'll be an opportunity to, and should be an opportunity for explanation and discussion.
Okay.
Public forum. Yeah.
Fair enough. All right, so we'll delete it. And let's move on to the second one now, the definition of goods. And what we had this on page 7. And we had discussed, we need to include money as goods. And the term any other thing capable of being transported was seen as sufficiently wide to enable the inclusion of money. But it'd be good to place it expressly on the list so as to remove any doubt. I'd requested the technical team to consider the matter and inform the committee as to what, you know, but if we would we'd put an F and we would say money. People do take banknotes in and out across the border. So it is a good in that sense. It can be a good. Do you have any objections including money in there?
No, I don't. I personally don't. I think we should.
Okay, money / currency. Okay, Ms. Edwards?
Yes, Minister, noted. And just to advise as well that we had done further consultations with Taxation Policy Division of the Ministry of Finance, as well as Tax Administration Jamaica, to just look at this question, and we are satisfied in proceeding in that direction.
Okay. The third was on the definition of Suffrance wharves. I thought we had dealt with this. The stakeholder was of the view that the provision should be amended to make it clear that goods must be owned by the operators of Suffrance wharves. I mean, definitely. I thought we had agreed to that, right? That it has to be clear that the goods imported by the Suffrance wharf owner should be goods owned by the Suffrance wharf owner. They raised the concern the definition did not capture the idea that goods must belong to the owner or the operator of Suffrance wharves or must be a specific type. And the power is to be granted, currently the power is with the minister to permit goods not belonging to the Suffrance wharf owner to be imported. And I think we wanted to keep it that way rather than to shift it to the commissioner. Do we need to make any change? I thought we had dealt with that.
I'll make a note. Minister, we had dealt with it, but I was not sure when I looked at my records as to whether we had taken a final decision on it, because there were some members who still had some concerns. I know that you had expressed your views on it, but there were still some concerns. And just to also indicate that after we had discussed this matter, Customs did further consultation with the Port Authority of Jamaica, who are also in support of this approach.
Does anybody have
so if it is now
approach?
agreed?
What's the approach being?
No, the approach is that the definition of Suffrance wharf should include the fact that the Suffrance wharf owner, as is the law today, can only import goods for which the Suffrance wharf is licensed for, first of all, and goods that the Suffrance wharf owner owns. In other words, he can't provide a service to a third party.
Yeah. Chairman, I'm in total support of that. In fact, I don't see it any other way.
It can't happen any other way. It's not even a debate.
Yeah. So I'm totally in support of that, Chair.
Right. And any
No, I don't think that was the issue. I think we're agreed on that. And then the question was a role for either exclusively or in conjunction with the commissioner and the minister. I think that's where the discussion, if I recall. And I'm in support of a view of the commissioner making a recommendation to the minister.
Chairman, I'm not clear on the point Member Hilton is making.
No, what he's saying is for the Suffrance wharf owner to import goods that don't belong to them would need a waiver. And the question is, how should that waiver be granted?
Chairman, I'm very cautious against waivers like that.
Yeah. I mean, Member Hilton is suggesting that you have to have you're going to need the law to allow for that rule to be, for the flexibility for that rule to be softened in times of disaster, for example. We've had to use Suffrance wharves to import items that we need. So one couldn't, you need to have an avenue for a waiver. But at the same time, what we don't want is for Suffrance wharves to be abused and for waivers to be the habit or the practice. So Member Hilton, you had suggested that there's a recommendation from the commissioner, and upon recommendation, the minister can approve or not. Is that what you were suggesting?
That's my suggestion.
And what happens now? What happens now? Who can advise what happens now? It's just the minister now?
I think so. That's my understanding.
Yes, it's the minister who takes the decision. No, I mean, there may be a recommendation, of course, from the commissioner, but it's the minister who takes the decision.
Right.
Yeah, but Chair, I agree with some flexibility, but I'm still not 100% comfortable. What you described, if there's a disaster and there's no alternative to use the Suffrance wharf, I'm not sure how we can capture that, but I'm not 100% comfortable because these things can be abused.
But no, they can be abused. But we've had situations in the past, for example, let's say something goes wrong, we've had the cement company out of commission in the past.
Exactly, right? Minister, exactly.
And we've had to, that's not an everyday situation, and God forbid that it happens again. But in a situation like that, you might need to import stuff temporarily using a Suffrance wharf. And just giving that as an example. But I agree though, Senator Webber, that that's very dangerous if not used correctly. It can have a distortionary effect on the market, and it can confer unfairly advantages to certain parties over other parties. So there needs to be some kind of transparency around it.
Yeah.
Having a two-step process is probably an improvement for what we have today.
Correct.
That the commissioner would need to recommend it, and then the minister approves it. Is that what?
And what you're saying?
Can I have the Ministry of Finance's view on this, please?
Yes, Minister. This is Ms. Wade Folks.
Yeah,
currently, the recommendations come from the Commissioner of Customs and the Port Authority. And on the basis of those recommendations, the minister approves.
But is that by practice or by regulation or law?
By practice.
No, that should be put into some regulation or law.
Yeah, well, I mean, if the Port Authority and the Commission of Customs recommended to the minister, I agree that two-step would be, if we can try and crystallize that in the law, that would be good. But Minister Chairman, you used the word of transparency.
Yeah, maybe it should be disclosed. It should be published on the website of the Ministry of Finance.
Yes, absolutely.
Because here, I mean, an important flexibility that has to be retained, and I want to be clear on it, right?
Yes.
The minister does not have to go by the recommendation.
Right.
Okay.
Right.
And I don't think you're going to want to constrain that either. At the end of the day, the minister is acting as a representative of the people, and there may be good reason. But if the minister, there's nothing that would be more, that would incentivize the right kind of behavior than if these decisions are made public.
Yes. So Chair, I agree, based on Pamela's intervention, that what is currently being done. So if the Commission of Customs and the Port Authority both recommend to the minister, and the minister don't have to approve it, as you said, I agree with that position on the basis that it would also be fully disclosed.
Yes, but I'm making it clear that the recommendations come from those two public officers. The minister doesn't have to go by those recommendations.
That's right.
If they recommend don't do it or do it, but if the minister grants an approval, it should be disclosed on the website of the Ministry of Finance. I think that would be a big step forward. That's not the case today. That would be a decision that this committee is making.
I agree with that recommendation. You would have my full support, Chairman, Minister. Full support. That sounds like we're absolutely moving in the right direction.
Moving in the right direction. Commissioner, your thoughts?
Yes, thank you, Chairman. Just to say,
I'm not hearing you. It's not loud. I'm hearing you, but it's not loud enough. The volume.
Is it any better, Chairman?
Yes.
Yeah.
Okay, wonderful. Thanks again. So just to say that as it is now the current procedure, it is not a recommendation per se from the Jamaica Customs Agency and the city. As I understand it is the request comes from the Ministry of Finance asking for whether there are no objection. And we will do our analysis of the situation, how it impacts us by way of security, by way of risk of certain procedure and the revenue, and then indicate that.
Yes, that's correct. That's a more precise.
Yeah.
And I think we want to keep it that way. It's a no objection from the Port Authority and no objection from Customs. Right. That's what we receive. And then the minister makes a decision. The minister can ignore the no objection or abide by it. But what we're adding now is to say that it's disclosed. Now, can you think of a case where, it's confidential or commercially? No, it should be disclosed, period. You have a problem with that?
Oh, no.
Okay.
I agree.
All right, Minister of Finance, let's wait, folks. You're on board with that?
Yes, Minister, I am.
All right, so to the drafters, hope we can capture that Suffrance wharf, the procedure for Suffrance wharf to bring in goods that are outside of their license or goods that don't belong to them require an application, obviously, to the Ministry of Finance, and a no objection from Customs and from Port Authority to be received, and for the minister to make the final decision. The minister is not bound by those no objections, but if the minister makes a decision to grant that waiver, it should be publicized on the website of the Ministry of Finance and Public Service. It should be made public. Okay, that's a productive discussion there. And I think that represents a step forward in deepening, fiscal transparency. Thank you, members. All right, let's move to the fourth one, which is clause 3(2)(b). Oh.
One that was discussed at length. Minister,
Yeah, no. This
I
was
wasn't sure if we had.
No. We had, I have it
Very
crossed
well.
out in my book.
So,
This was
right, just for us to have
any
a definitive notation.
Yeah, no, this right. We had discussed this at the time, and it had to do with no import duty shall be payable on any article imported in Jamaica by any person and shown to the satisfaction of the commissioner to be required for a charitable purpose. No, we have a whole scheme for this already, a whole law called it Charities Act, through which goods intended for charitable purposes can be imported without duty. So, I mean, I guess this discussion is, I thought that we had dealt with this already, to delete what is written at clause 3(2)(b). Any objections to that?
Well, Minister, just to say that members of parliament and ministers and former ministers will tell you that although you have these regimes, this is not in its application very simple matter, and that there continues to be a lot of complaints around this section, particularly from our diaspora members who are attempting to send goods. Now, I'm not saying that all procedures have been followed, and that's not the reason for the complaints. But I think it may be an opportunity if we take it to see whether any improvement on the existing arrangement involving customs or not it can be looked at to improve that.
Yes, look, you're correct. As a member of parliament, I'm fully aware, and as Minister of Finance, of how this issue intersects with day-to-day realities. I mean, literally every week, just yesterday, a member of parliament approached me with a matter brought to them by a constituent. What I recall saying at the time, and I repeat here, is that what we need to do is to reform the Charities Act. Right? The Charities Act is very clear. It provides a rules-based mechanism. What this was seeking to do was saying to the satisfaction of the commissioner. That's not rules-based, right? So it's pretty dangerous how it's worded, because it would be, oh, the commissioner believes that this is being imported for charitable purposes. Okay, you can go. She doesn't believe that that's important. Oh, she can't go. No, that's not rules-based. So in the Charities Act, which was passed by administration which you served as minister, Member Hilton. In fact, it was the first bill I ever dealt with in the Senate. Provides a rules-based mechanism. There's a charitable organization, it's registered, whatever it imports, it can be relieved of customs duty. What happens as a practical matter, there are a couple of things that happen. One is people don't want to go through the process of registering charities, which maybe we can make it simpler. Maybe we can reform the Charities Act to make it simpler. Maybe we can have a general purpose, charity to which members of the diaspora who want to donate things can donate to, so that charity can bring it in for them free of charge, right? So those are the innovations that I think we need to make it easier. The practical thing that people meet upon, though, is that while we can relieve the duties, there are other fees that are associated with importing goods that government, in some cases, has nothing to do with, right? There are private sector charges and many times people encounter these and say, I had one of those just yesterday. And it turned out when you looked at it, I said, wait a minute, but you use the imported charity, you got the duties waived, but all these fees I see here are from the private sector. Transportation, your custom broker, you're this, you're that, you're that, you're that. And people are not familiar with the process and things get really confusing. But how we address it is not through this what we've written here would get us into serious trouble.
I'm in agreement. I'm in agreement, and I acknowledge that in what I had to say, which is that it
Yes,
may,
you did acknowledge it. Yes. Yes.
the solution may lies outside of that.
Yes, it does. All right, let's move on. The fifth one is clause 11, responsibility for the payment of duty. And we had some discussion on this. And let me just read clause 11. Oh, it's a long clause. Can't read all of it. But I think what it had dealt with is that it was in subsection 6.
Yes, Minister. And
yes, a person who has acquired or stored goods in respect of which a condition or obligation referred to in subsection 4 or 5 is not fulfilled, observed, or complied with, or aided or abetted in the failure to fulfill, observe, or comply with a condition or obligation referred to in subsection 4 or 5 is a debtor if that person knew or ought to have known of the failure to fulfill, observe, or comply. So here, it's basically putting obligation on the service provider for know your customer, et cetera. And in the discussion, what we had set as a compromise, even though it has been swept up into these goods to come back, is to insert the word reasonably. If that person knew or reasonably ought to have known. And I believe the word reasonably would probably address the concerns that were raised. You know, we can't totally absolve responsibility, or else you're going to get complicity, right? And if you get the complicity of one of the authorized persons in the chain, then you're in real trouble. If you have a system where this authorized person, and authorized is the wrong word. This what's the right word I'm looking for, Hazel?
License.
this debtor.
Yeah, this licensed
person.
If you have a system where this licensed person can be complicit and escape responsibility, because if somebody gets caught, it's just the importer or whatever, then you're going to set yourself up. So what it's seeking to say is that if you reasonably ought to have known, then you are caught by the provision. Some things are not reasonable for you to have known, but there are other things that are reasonable for you to have known.
Well, I tend to agree. What really is at stake here is the revenue protection one, but also that persons who are licensed have a responsibility, I think. The KYC comes into play as well, knowing your customer. But the business can't be simple about collecting fees, your service charges.
All right.
With every business, there are some rights, but there are some responsibilities. And I think that I agree that the reasonably should have known, should balance the scales somewhat, rather than a strict liability provision that may otherwise could in effect could be affected if the person doesn't pay, then the broker or whomever, agent or whomever, is liable almost a strict liability interest. So I'm satisfied, personally satisfied.
Okay. All right, if no other comments, we'd move to the next one, which is we have about 36 of them, and some of them are going to be substantial. The sixth one is a 19.2a. And this is simple. There should have been a comma between the words cigarillos and cigarettes. Yes, obviously. I don't think we need to be detained on that. The seventh one is section 20, subsection 3.
Minister, and I believe that this one had been agreed in principle. I think what we do now need to present to the committee would be the proposed language. We had
You want to handle this one? Go ahead.
Right, we had sent some.
Just read it, please. Read the original clause so people can bear.
Well, it's not a question of an original clause, Chairman. It arose under clause 20. And these are the comments from the Revenue Appeals Division where they were indicating that clause 23 could perhaps be expanded to make it clear that the commissioner had the power to reject declared values. When we looked at it, and having further consultations with the RAD, we determined that the best approach would be not to deal with it at clause 23, but rather to deal with it by inserting new language in the valuation schedule, which is a second schedule. So, and this is the whole issue of giving effect to the WTO decision 6.1, right? So we had sent information to the CPC. I think we would just perhaps need another opportunity to just get that language back from the CPC for inclusion.
We can defer it until the next meeting.
Yes,
right?
yes,
But you have
just to get the language.
Yeah, okay. All right, moving on to the next one. It's clause 30, subclause 1AI. And let me just read what it says. It says, without prejudice to any power exercisable under section 27 or 29, the commissioner may, by notice published in the Gazette, designate one, any place as an authorized place for the loading or unloading of any class or description of goods, hereinafter referred to as an approved wharf. And the question was whether the commissioner should have the power to determine places of embarkation and disembarkation of passengers. And the suggested approach was that, look, this power to designate such places should be deleted. This power properly rests with the minister responsible for immigration, as far as people are concerned. And this was, I think this was agreed, but we're just doing it for clarity. That what we said, we would not make sure that this clause does not refer to people, because you would be encroaching upon the responsibilities of the Minister for Immigration.
Correct.
Okay, so the provision is to be deleted. This is for the people part of it. Is that right, Ms. Edwards?
Yes, Minister, in relation to the power so for embarkation and disembarkation. Minister, of people. I noticed I don't have it there on the matrix, and I know it wasn't noted specifically in the minutes, but there had been some discussion around clause 31E. I don't know if we are satisfied in relation to that issue. Some concerns have been raised about
1E.
Yes.
30 subsection 1.
Subsection 1, paragraph E. And there have been some concerns about whether or not we're satisfied in terms of the provisions for disaster preparedness. I think we had looked at it. There were discussions that, we had other legislation that could grapple with it, but I just wanted to be sure that all concerns in relation to that issue are now resolved.
No, so E dealt with?
It's a power of the commissioner to meet the exigencies, in meeting the exigencies of any case, designate any other place to be an authorized area for entry, loading and unloading of goods. Right.
Yeah,
so it could be an emergency scenario, the ports are.
I wouldn't want to dilute that authority though. I mean, the commissioner has the knowledge and information.
Yes.
And, presumably interacts with other members of the public bureaucracy and can be advised. But I think it's better if that power stays with the commissioner.
Chairman, may I comment?
Yes, please.
But wouldn't this be almost as a Suffrance wharf? And if so, doesn't that power would lie with the minister?
No, my observation is that, Mr. Chairman, is that you assume if the option is a Suffrance wharf, fine. But if equally for the same emergency, if the Suffrance wharf is not the appropriate place, then you need to find some other avenue, some other opportunity for the goods to enter or to leave.
No, what I'm saying, remember, Hilton, is that once there's a place outside the normal designated wharf area, and those places termed Suffrance wharf, and therefore it would be on the discretion of the minister or under the authority of the minister in that case.
No, so remember, Don, what happens is that the approved wharf comes under certain regulations, certainly of the Port Authority, that don't apply to Suffrance wharf. So they have a higher burden to bear, right? Because they're in the third party business. So having the minister just gets involved for those who are going to fall outside of that specific regulation. So Customs Commission is rightly the person to deal with approved wharves.
I agree. And I think the issue, Minister Dunn, is the point the minister, the chairman, is making, that a Suffrance wharf is a specifically defined area and activity. If it's outside of that, then the question is, particularly in the case of emergency, who else should appropriately identify an appropriate.
No, and I believe the minister should be.
And the minister is saying, and I think quite correctly, that designation. Well, I can see your point about having the minister confirming that, but I think the Commissioner of Customs is the entity and the body that has the technical knowledge and information. Now, whether in the case of the emergency, you want the minister to have a final say on that, I think it's really the only question. But that Customs should have a role in it, I think, is very clear.
No, I'm not saying Customs should have a role in it, Member Hilton, but because of the exigencies of the situation, and since government regulates policies and directions, then I believe that the minister should have the say in a case like this.
The commissioner, you may be more comfortable with the commissioner recommending again to the minister for his approval.
How does it work? How does this work now?
This isn't okay. I'm wondering whether or not Member Dunn's concern would be addressed if Member Dunn is concerned that this could result in the commissioner authorizing unloading and so on to occur at Suffrance wharves, and thereby sort of diluting or bypassing the power that we discussed before that should rest with the minister to determine that the Suffrance wharf is to be used for something else, or to only to be used for specific purposes. But this provision is intended to deal with instances where you may have an overflow, right? You may have crowding on the port and items need to be temporarily moved into a particular space for safekeeping or for unloading or so. That's what this is intended to do, not to create a Suffrance wharf, because a Suffrance wharf has to be designated by the minister, and not to allow a Suffrance wharf to be used other than as ordinarily the wharf will be used without the permission of the minister. So it's not intended to operate in that sphere at all. And so I'm wondering whether or not, if we had the words to meet the exigencies of any case, designate any other place, perhaps other than a Suffrance wharf, to be an authorized area. So you put it beyond all doubt that this power of the commissioner is not to be exercised in relation to Suffrance wharves.
That would probably meet his memo done.
I'm wondering if that will.
Yes, Mr. Edward, yes.
Okay.
Yeah,
great.
so I think that clarifies it for me at least.
Okay,
All right.
great. Thank you, Member Dunn. I mean, Minister Dunn, rather, and Senator Allen. All right. The next one, I believe, is clause 33, subsection 1. Imported goods come under customs control from the moment the goods are imported until the goods are cleared for free circulation. A member had raised the concern that the meaning of the term cleared for free circulation as used in its provision is unclear. The customs agency, I think, agrees that the term cleared should not be used. And the CPC, oh, this was agreed in this committee.
Yes.
It was agreed in the committee. This one, I guess,
Yes.
Ms. Bailey, you're being very, very thorough by
Well,
presenting, or you did it, not Ms. Bailey. You.
Minister, I must admit that the blame doesn't lie on Ms. Bailey's feet. Yes, I'm the one who prepared this document. I just wanted to ensure that definitive decisions are taken.
This was dealt with.
Yes.
Yeah.
But there was also a follow-on concern that my notation, I was not certain if we made a decision on, or if the concerns had been addressed. And I know that members had raised concern about the use of the term free circulation, in particular Member Hilton. And it was agreed that after we've gone through the entire document, members would see whether or not they still had any discomfort and understood the concept of free circulation.
Yeah, I do recall raising the concern about free circulation, and that would be, I've been spent some time this morning talking about customs clearance and customs, and still having customs oversight of the process. That free circulation then speaks to the fact that the customs is home use goods, for example, fall under free circulation or just strictly commercial?
So the concept of free circulation refers to the idea that customs, you are finished with customs. So we actually go, so whereas before we were thinking that clearance referred to that, Member Hilton, really when we talk about free circulation, what it means now is that those goods are now outside of customs control, and customs has no further, will be exercising no enforcement or control over those goods. So remember I mentioned that goods that are in, you can have goods that are in home use that are not in free circulation. And a classic example would be goods, a motor vehicle that has been cleared pursuant to a motor vehicle duty concession, right? So it has been cleared for the home use customs procedure, but it is not in free circulation because customs still has an interest in those goods in terms of ensuring that the terms of the duty concession are complied with.
Okay.
But if there are no customs restrictions that apply to those goods, then the goods are said to be in free circulation.
And that can be both for commercial and home use goods?
It could be for commercial and personal use, yes.
Okay. Chairman, through your chairman, Ms. Edwards, when we spoke about the whole clearance procedure earlier, and we had that long debate on the process, which you just explained. I lost it for a few minutes. I'm not sure if in your discussion you had mentioned it, but could we add in this for clarity after the concept of cleared for free circulation? We could add and customers completed the clearance process, because remember, as you said earlier, the clearance process, the fact that you have cleared the goods, and if it's still in free circulation, custom can still have an interest in it. So to avoid any ambiguity, could we add that section, or it's just not necessary? And the section that could be added is, and has completed the clearance, the custom clearance process.
No, Minister, what she's
No.
saying is that you can complete the customs clearance process, but the good is not in free circulation. And she gave the example, which is a common example, easy to grasp.
No, I missed a part of the discussion, so I'm not sure.
And she's giving an example of the motor vehicle concession. If you have a concession on a motor vehicle, certainly the concession that applies to, persons who work in, select persons who work in the government, whereby you're required to hold the vehicle for 3 years before disposing of it, and failure to do so will mean that the duties become immediately due and payable. That motor car is not in free circulation until those 3 years have passed. Because if you sell it after year 1, the customs authority has the authority to ask you for the duty. All right, so that's an example of a good that has, in the popular imagination, gone through the custom clearing procedure and is physically outside of the customs control area. It's in your garage, but it's not in free circulation as legally defined using the, as according to the Customs Act, because it's conditional. The release is conditional. And it's conditional on you keeping that in your possession for 3 years.
And customs still having an interest in it.
And customs still has an interest. And there are many other examples. What is happening now with the waivers we've given for people to take stuff out of free zones, more, to facilitate work from home is another example.
Okay.
Right.
So once it's in free circulation, custom has no more interest.
Exactly. In free circulation, customs, you're done with customs.
All right, thank you.
And 99% of the cases, that happens after you leave the customs control area. But there will be cases where customs interest follows the good to wherever it's going outside of customs. Okay?
Thank you, sir.
All right. 36.3, production of goods deposited at a customs control area. An operator of a customs control area who fails to comply with a notice under subsection 2 commits an offense and shall, in addition to the applicable penalty for the failure, be liable for duty and tax in respect of the goods. A member had queried whether an operator should not also lose his license if an offense under this clause is committed.
Right. And so, Minister, at the time when this issue was raised, JCA had indicated that we would have no objection in principle to putting in, such a provision. But on further review, we are of the view that it may not be necessary because the license to operate the customs control area would in fact be an authorization under the Act. And we do have provisions that deal with the consequences that flow when you breach the conditions or the terms of an authorization. And so we're satisfied that the issue is
that option
adequately addressed.
Right, that option.
Yes, because if you breach the term of your authorization, the license may be suspended, it may be revoked, and we have a number of provisions that treat with that.
Yeah. Okay.
Minister, the other issue though was that I remember the concern I had there where it is the operator, and if you're talking about in many of these instances, either it's in a zone, a special economic zone, it could arise. It could arise in a factory within a zone that the operator of the zone is not necessarily the entity operating or carrying on the production or the activity.
Mm-hmm.
The question is, as it is throughout this Act, is what sort of liability you want to impose on the operator who himself or herself is not the entity or the person carrying out the activity. I think that was when I raised the concern first, that was the issue for me. I don't know that this discussion addresses sufficiently that question, or am I missing the point here?
No, well, the operator of a customs control area is going to be an airport operator or a wharf operator or somebody like that.
Special economic zone. Customs control area.
Mm-hmm.
Yeah, so you have multiple actors in the case of, say, a special economic zone. You have multiple actors.
No, but this is saying, this is something that the operator fails to do. If the operator fails to respond to a notice, it's very specific to the operator.
Okay, fails response to a notice.
Yeah.
Okay, there may be something else, because
yeah, it could be, I think it might be on another section.
Okay, okay.
We still have about 30 to go, so it is going to come up.
Okay.
All right. This one was agreed as well, but I'll mention it just in the sake of completeness. 39(1)B, unlawfully remove goods from a custom controls area, whether the letter S should be added to the word destroy. And I believe we agreed that it should have. And that is a person commits an offense who embezzles, misappropriates, or unlawfully converts any goods duly warehoused or deposited in a customs control area, or unlawfully destroy any such goods. Yes, S should be added. No need to waste any time there. And we had agreed to it. The next one was on clause 47, subsection 1. And it's proposing some words to be moved to the margin. The commissioner may, by notice in writing, require a carrier to submit to the commissioner all information specified in the notice, being information, blah, et cetera, et cetera. And somebody wanted to have, and a carrier who fails to comply with the notice commits an offense. All right, we had that in B. And I want it moved to the margin. Yes, of course, yes. It should not be in B. That's a typo. It should be moved to the margin. Yeah, 47(1)B. That was agreed to. It shouldn't really be on this list.
Perhaps, Minister, you could just review the matters that would remain outstanding.
Yeah, right. Yes, I will. That's what I will do from here on. So you want to tell me those?
There was one issue at 16. I've listed it there at 16. Read clause 87(1)B.
Yeah.
But Minister will just ask for an opportunity to just finally confer with CPC on this, and this has to do with the time frame that needs to be inserted in relation to that particular clause.
So you want to defer this one?
Yes, so I wish to defer this one. And
Let's
then the next.
Tell everybody what it is then. 87(1)B, deemed clearance.
87.
Imported goods may be treated as if the goods are declared for home use if the goods are damaged, destroyed, or unaccounted for while under that procedure, and the damage, destruction, or failure to account, as the case may be, is not attributable to a cause prescribed by regulations. Okay, that's what we'll defer to the next meeting. Okay.
Yes.
All right. What's the next one that was not dealt with? Yeah, you're right. You have a lot of things here that were agreed to.
The other main one
122
has to do with clause 1. Yes, but I believe that we would need CPC too, because that is a matter to be finalized with CPC. So I'd ask to defer that one as well, because that has to do with just language, not so much intent, but clause 132. There was a proposal that we had put on the table, and I don't believe we had agreed on that.
Let's read 132. Read it, please. All right, I'll do it. The burden of proving that goods temporarily admitted into Jamaica were re-exported from Jamaica in accordance with the applicable export procedure and within the period specified under subsection 130 in relation to the goods shall rest on the declarant.
And there was a proposal there that the provision should be expanded to include, to indicate that responsibility would rest not only on the declarant, but on other persons who are responsible for meeting the requirements regarding the temporary admission. And this would include, for example, guarantors.
So how would it be reworded?
Shall rest on the declarant and on any other person. I mean, obviously I'm different to CPC on the language, but and on any other person responsible for complying with
the temporary admissions procedure?
Yes, language to that effect.
All right, any objections?
Minister, would I be going a bit too far, Miss Edwards? Because most of the time those goods would have been yeah, and therefore the declarant would be almost a sole person responsible for those goods. Miss Edwards?
Yes. I mean, the declarant is the principal person, but we thought it would be appropriate if someone had put up, for example, a guarantee that the conditions of the temporary admission procedure would be met, that if there is non-compliance, that guarantor also be held responsible, so far as allowing obviously customs to draw down on that security.
I understand what you're doing, Ms. Edwards, but I think I'm a little bit uncomfortable. Chairman?
Yeah. Listening.
No, I'm saying that I'm a little bit uncomfortable. So for argument's sake, I am the declarant. I'm the one who brought the goods into Jamaica. Don Webber gives me a guarantee, right? But the guarantee is in good faith. The declarant, I believe, is a person that all penalties, all aspects of the law should be booked, not necessarily the guarantor, because the guarantor would have done it in the normal course of his business by offering guarantees for the landing of those goods.
The point Member Dunn is onto something. I think we need to look at, whether that would work and a disincentive for persons who are in the business of giving guarantees, so that they are also guaranteeing not just the ability to pay, but also guaranteeing the debt. If your role is to make available, to give such guarantee, we may want to see how that would work at this incentive in the system, Minister. You could ask someone, Mr. Webby, if he's still on, perhaps can give a view. For example, I mean, that certainly would be a risk to him. That would be then, I suppose the minister would say that's a risk, and that could be calculated into the fees charged. But yeah, this is particularly true because you need a guarantee if you're not well heeled in the first place. And that's probably an imposition that we need to see how in operation that impacts micro, small, medium-sized enterprises, for example.
Yeah, but so I guess, and I'm trying to follow Minister Dunn and yourself, but in normal business practice, Chairman, one would require a guarantee, and a certain amount of due diligence would be done to ensure that that guarantee can stand up to any call. So I'm not quite clear where Minister Dunn is going after having said that.
So what good is a guarantee if it can't be called?
Yes, that's what I'm saying. And
What's
that's
the
what I'm
purpose
saying.
of it?
So when a guarantee is issued, a business person would assume that it can be called and that they would have done their due diligence to ensure that it has a backative, so to speak, in quotation, to be called.
But Don, wouldn't it be called in the course of doing that business and not necessarily in the risk being passed from the responsibility of the debtor?
No, but that's why you issue a guarantee, Minister. It will be called if the debtor fails to pay.
No, I understand that.
So I don't think it's a matter of passing risk, it's an understood risk. That's why you issue a guarantee with the understanding that it can be called, that is how you hedge against that risk. Chairman, you follow what I'm saying?
No, I definitely follow. I mean, the problem, Minister, is that the purpose of the guarantee is to act as a dissuasive, or to provide the avenue for dissuasive penalty.
Absolutely.
And if at the time when the penalty needs to be applied, the guarantor has escaped, then you have
yes, and that's why I use the term, Chair, appropriate due diligence must be done.
Yeah.
No, I think that perhaps the only question is at what stage you call that guarantee. I mean, is it the first call? I mean, at what stage the, you know?
No, I mean, I think that the legal procedure there is well established as operational. All that we're saying here is that if you brought the goods in temporarily and you got a permission to do so duty-free, on condition you would export it, and somebody came to guarantee that you would do so, and you did not export it, as you said you would, and come on, life is serious, man.
Yeah, that's business. That's
business.
Yeah, no, I missed the part about transferring the goods. It's temporary. Yeah.
You just open a good loophole there.
Yeah, I thought the goods are here. And he's having use of the goods at all. But if it's no, I'm fine.
Yeah. Or else, you get, I forgot.
Yeah.
What you gonna do now? Yeah. All right. So we proceed.
So, Chairman?
Yes, Commissioner.
Yeah. So should Justice say that in terms of what currently obtains as per the Act of 1941 and what we're presently doing, and just to show where we're moving as regards to this new bill in terms of the greater facilitation and flexibility, is that for the temporary imports, you would have to pay a deposit equivalent to the duty. And should you not export, then we already have that deposit to pull down on. So that now this new arrangement tend to ease it a little bit.
Yeah.
Right. So just to indicate that the act
right, we're moving
giving, right.
No, thank you for that intervention, Commissioner.
Yeah, well, that's better. That's better.
Yeah, so you make some movement here, Minister. You can report to your constituents that we're improving it. No longer, thank you, Commissioner, for reminding me of that. No longer will you have to put up the cash. You just sign your name and say, I'm good for it.
Yeah, bond. You usually require a bond. Good.
Okay.
That's facilitation.
Right.
That's facilitation.
Thank you, everybody, for
Thanks,
that.
Commissioner. Thanks, Commissioner.
Yeah.
The Chairman, the next one, if I may move it to, is clause 155.
Yeah.
Subclause 6.
Mm-hmm.
And this was a matter that we discussed at length, but I do not believe that a decision was taken. It was indicated that there will be no change to the provision.
That's
at
good.
this time.
Take us through it. We want to read it and what it refers to.
Yes, so 150, clause 155 is the rate of duty upon reimportation. And subclause 6 is subsections 3 and 5 shall not apply to a repair for the purpose of maintaining or placing goods in working order. And the discussion surrounded goods that are routinely sent overseas for maintenance or repair. And the question as to whether duties and taxes should be charged on the cost of that maintenance or repair work. Customs had recommended that the clause be deleted because we were now conceiving of a scenario where, well, certainly in our mind, if the goods are sent overseas for the repair works, then the cost of the repair works would essentially be the value of the goods when they're reimported, and the duties will be charged accordingly. There were concerns raised that this may be prohibitive for persons who are sending items overseas in cases where the servicing or the maintenance is not available in Jamaica. And so the item has to be sent overseas, whether it's equipment or even a watch, for example. There was a suggestion during the discussions to.
And also a problem, you can't prove what the repair value is. It's not like you can look up what a John Brown computer is supposed to cost. When you say the watch was repaired for $1,000 and customs say, how could it be repaired for $1,000? I mean, how you have no way of determining the value of a service in that way, right?
But Minister, wouldn't the value be based on the proving what was spent for the repairs?
No, I'm saying customs has no way of independently verifying, and so you could end up with serious.
Minister, normally you can.
Huh?
Normally you can. Normally the person who take all the goods and bringing back the goods will have an invoice or repair bill or something like that. So you'll have a value to base it on.
So, Mr. Edwards, so you're saying if there's a specialized machinery, I was trying to understand the process. If there's a specialized machinery on some production line that cannot be repaired in Jamaica, and it is sent overseas to Germany, or let's say it's a brewery, and it costs 100,000 Jamaican, and I'm just using a figure, to repair it. You say on the reimportation of that, duty should be charged on the 100,000?
That is what is being contemplated, because when you look at how subclause 5 operates, subclause 5 provides for that the duty will be charged on the cost of the repair. But then we have the subsection 6 being introduced and saying it should not apply to repairs for the purposes of maintaining or placing goods in working order. And when we looked at it, we were just thinking practically, how do you determine what types of repairs fall under the subclause 6 versus the ones that would ordinarily fall under subclause 5? Because how things operate now is that if you send the item overseas, yes, you would pay the duties on the value of the repair. But it is recognized that there are some items that may routinely need to go out. And we can acknowledge that if that is the case, then that could be quite expensive, right, for the owner of the equipment. But how do we make the distinction?
Yes, I hear you. it's a very gray area, huh?
Yes, and the language here is not sufficiently clear.
Yes, no, I agree with you. So what you said is being recommended, that section 5 be deleted. That's what you said?
Not 5, 6.
6, sorry, 6.
So the rule would simply be, if you send items out for repair, when the items are reimported, duties are charged on the cost of the repair, on the value of the repair.
Yeah.
My concern there, Chairman, from the beginning was that from a production point of view, it's one thing if you're talking about a consumer item, and I'm not saying that I don't have concern in that area. When you look at a piece of equipment integral to a production process, and you have to send it for repair simply because it's probably more expensive to fly a team of persons down here.
That's right.
And you send it abroad to get your production back up. You're really looking at a situation where you could be paying for it twice, or a time and a half. I mean, price and a half. I'm not sure how that incentivizes. It would cause factories to almost run themselves in the ground. People don't want to. When you look at the cost of doing it, you probably say, well, let me just get full use until it's done and then just buy a new one.
I agree with Member Hilton. It will become almost a disincentive.
Yeah,
and all that, so I mean, the cost of that duty done, that duty on that repair might be so insignificant to the production process that production line would be down, and the foreign exchange earning capacity would have been lost.
No, I agree with Minister. I agree with the Minister Dunn and member.
Well, we can construct any example to make any point. I love how the example has developed and become. but I understand the point. But here's a question: wouldn't productive input relief apply in the example that has been cited?
I don't necessarily think so. On new equipment.
Yeah, I don't think so either.
No, I'm saying the principle of productive input relief. I'm saying the principle is if the item were new, you wouldn't pay duty on it. So why would you pay duty if you repaired it?
That's an interesting point.
You wouldn't, Minister.
Right. So how do we, I mean, if we were to say the class of items under which productive input relief would normally apply, that principle would carry over if you had sent those items abroad for repair.
Well, recall, Minister, that the product PIR would only apply to persons who are registered, recognized as manufacturers.
Well, that's the example
so
given, right?
Right. So if we intend to limit it to those persons who are manufacturers, then we could delete it from here and make an appropriate provision in the first schedule, right? Where we have the provisions that deal with the PIR. We could indicate that if you send equipment out for maintenance or so, then that would be the best place to do so that it is restricted only to the approved manufacturers, if that is the intention.
Minister, could I ask a question?
Yes, please.
So we also have to bear in mind that we do have a service industry here in Jamaica.
Yes.
So if it is that we go the route of saying you are free to go abroad, wouldn't that have a deleterious effect on the local service sector as well?
Yes, that's why it's a complicated issue in that, and I made a point, you can construct the example to make your point, that in the area where you have a choice between service in Jamaica and service overseas, and you choose to go overseas, I mean.
But why would someone choose to go overseas?
Yeah. Well, it's a way we choose to buy the shoes made overseas and the barter shoes made in Jamaica, right?
I'm not sure if that's a good example, Chair, because I mean, from my experience at Grace Kennedy, the only reason why I would send something overseas, 'cause it cannot be done here.
Right.
No, I understand, but I'm saying that, you remember when we make a law,
Yeah.
the law has to apply to all circumstances. So I'm just giving you another circumstance, which may not be Grace Kennedy's circumstance. It might be the circumstance with somebody with a high valued watch, or with a car or whatever that can be serviced here. But they choose, it's a choice. You give the example when it's not a choice, but it's a theoretical case where it is a choice.
Yeah.
If it's a choice, do we, we would be removing that duty barrier that other sectors benefit from.
Yes. Yeah. Yeah.
Right? Manufacturing sector benefits from duty barriers. We would have a service sector that doesn't benefit from that duty protection. So it's complicated. It's not.
Yeah.
May I ask a question as a practical matter? How regular do you come across examples like this today? Anybody from customs?
Not very regular, Minister.
Right, not very regular, especially from the business perspective.
Is once in a
Once in a while.
once in a while.
Yeah, no, I can support that.
It might be a little more frequent on the personal shipment side. Person take out something, maybe a computer to be repaired or something like that, bring it in back. But it's not a regular event, like every day.
Yeah, Chairman, I can support that because from our point of view, we only would do that in case of an emergency.
Correct.
In terms of a line may break down at one of the manufacturing plants, and we need to get it up back quickly for Vienna sausages or some, or the jerk sauce. And so we just need to send out an equipment quick to be fixed and sent back. So it's really, I would almost say it's really a one-off, you know what I mean? Whereas something like that would happen. Very, very infrequent. That is why when
maybe
that's why,
go ahead now.
No, that's why when you're saying about in the and I think Ms. Edwards supported it in terms of the productive incentive or how you refer to it. I think that's a good approach even to start, you know?
Yes.
Because you're right.
Let's do that then.
You're right. If somebody has a choice, one would hope that we incentivize them or disincentivize them to do the repairs in Jamaica to build up our own standards. So as you said, it's a very tricky situation, but I like that approach in terms of manufacturing productive emergencies kind of thing. I'm not sure how to capture that.
Suppose we address it that way.
But Chairman, can I say something? I mean, in the medical industry in particular, I mean, some of those equipment are so specific to the manufacturers that persons here might not have the capacity to repair them. So it's not that we're not incentivizing the local industry to develop, but the capacity maybe just not don't exist in at all. Or even if it exists, it is not up to the standard that those companies would have authorized an agent here to do that repair.
But as a practical matter, don't people come to service them in Jamaica? In the medical industry, you send the equipment out?
Some you send out, yes. Some you do send out. I mean, if it's an ultrasound machine, you might send it out. I mean, you don't get somebody come down to repair just that. Right. But if it's an X-ray machine, then yes, people come down to repair those.
But it's interesting that you use that example, Minister Dunn, because I saw something a few months ago where somebody came down to teach some of our engineers how to repair a ventilator with the COVID-19 pandemic. And we're on our own now. The persons at UA repairing ventilators haven't gotten that transfer of knowledge. You know, so
definitely. But that case to done is that you have sufficient quantities here that persons can in fact send someone to the train to transfer the skill here so they can repair. But if it's specialized equipment, you might not have that.
No. Yeah, I guess that's the same example as the manufacturer in terms of sending it out because it's basically, you don't have a choice. And that's what I'm struggling with, because if you have a choice, you want to ensure that the local practitioner, get the opportunity to do the job. But if you have a choice, and that's how you have to try and strike the balance,
Yes, and in those cases, Chairman, I mean, those persons will not benefit from the PIR.
Yes, I agree.
So just to make an observation, in the case of the healthcare sector, there are some provisions, again, in the first schedule that provide for an exemption from customs duties for a list of equipment, right? And that would be on page 603. I hope it's also the same page number in your books as well. So there's a list there. Obviously, it's not as, like, there may be items that are left off the list, but there are some items that are listed there, for example, the X-ray
No,
machines.
but you said it right.
So
you said it right, Ms. Edwards. Some items might be left off the list.
Oh yes, because it's not a very long list. It's not a very long list at all.
Just remember that PIR is not only for the manufacturing sector. It is for tourism, healthcare, music, industry, and so on and so forth, right? So it depends on how the clause is worded. It will maybe capture those other instances as well.
Yes, it will capture some types of equipment. So for the creative sector, some equipment is included.
Right, but in the medical, under the medical provision, healthcare, there's a list of equipment and so on as well that they're entitled to.
Right. That's what I'm mentioning, that there is a list there. I think it's a reasonable list, right? But there may be, I suspect, one or two items that are left out.
But Minister,
so I think the main issue would be
Right, Chairman, the question you had asked is, how prevalent is this? And I guess the answer lies in that.
Yeah. We may choose to just leave this for the time being.
I think, Chairman, I think to be consistent, there's some consistency and coherence in this question with the PIR, with the production incentive. And I think that's a minimum we can do, because you really need to recognize that is in place. And if the good fall under that category, then there should be no reason to pay duties on it if it's coming back in after repairs.
All right, and can we coalesce around that, which I think is where Senator Webber seems to be?
Yeah, I'm fine with that, Chairman.
So to be clear, Chairman, we would be deleting the subclause 6, but we'll be inserting a provision in the first schedule to allow for, items that are sent out for repair and so on, where it's in relation to a registered manufacturer.
Well, I know it's approved PIR, so it's broader than
approved in relation to the approved PIR.
Could be a bed.
Correct.
All right.
So, Minister, just to add that medical equipment also falls under the PIR because they do get benefits under the FIA.
Okay, good. Thank you for that clarification. That should satisfy the point that Minister Dunn had mentioned.
Right, and I don't want to belabor the point, but I just want to be clear that in relation to, because I know that the examples that had been given during the discussions related to, for example, the watch. So in the case of a high-end watch owned by an individual that is sent overseas for maintenance because it's not possible to maintain it here, the duties and taxes would be charged on when it comes back.
Yeah. For the value added.
For the value added. Is that Ms. Madge?
Yes, Minister. I just wanted to get it clear also in terms of, we're talking about making an amendment to the PIR provision for all the entities that fall in PIR, because you would have, as you said, you mentioned beds. The hotels would get all of those items. They would be allowed to send them out and come back.
No, but it's not practical to do that, right?
I know it's not practical, but they have televisions and stuff like that. I don't know. So we would just be thinking about, If it is, because initially it seemed as if we were going the route of the manufacturers and the medical. Now it seems it's all the entities in that area. Under the PIR.
You're right in that theoretically. Nobody's going to export one low valued thing for repair.
Yeah.
But if you have 5 hotels and you have 1,500 televisions,
yes,
it might be worth your while to export those for repair, and not pay duty when it comes back. But televisions can be repaired in Jamaica.
No, and if you have 1,500 of those, you bring, you bring a master, somebody, train somebody and get them done.
Yeah, I get it's just a principle we're saying, Mad, of if there's PIR to bring it in, and we're assuming that it must be a hassle to send it overseas. So you're only doing it if you have to.
Correct.
And if you have to do it, an original thing was brought in without, then the principle is you shouldn't be paying duty if you didn't pay duty on the original item. Now, if an industry emerges, right, and this creates a distortionary effect, and we see some industry emerges where people are abusing the provision, then legislature can step in.
I agree with that, Minister, Chairman. I think we should leave the clause. That's what I believe.
We should leave the clause. We should do it and use the PIR thing.
Not necessarily leave the clause as is, clause 6, because the question, I said the question you asked is, how often is this happening? And if it's not happening often enough, then it doesn't matter that much. But as you know, Steve, if an industry is emerging, then at that time you put in stuff to properly regulate that.
No, I understood it otherwise, that we say for coherence, for purposes of coherence, if the principle enunciated by the chairman, which is if you already have the PIR that says if you buy it and bring it in, you get a duty break. Why, if it needs repair, why would we be charged up?
But I understand, but I'm just saying it's not something that is happening that frequent for customs for it to raise a red flag to customs. So if it allows for persons who are in emerging industries who are not registered as an entity on the PIR, then at least they could in fact continue owning their craft as small businesses or MSME does, until it gets to a point where it becomes an activity now that should, in fact, require custom intervention on it, or from a revenue standpoint. But no, it doesn't. That's not the case.
Yeah, but you don't punish those who. I mean, and when I say punish, it really is. It's not logical that if I brought it in under the PIR, and it needs, and usually it's an emergency, we can agree. But it could be, as we've said before, a very valuable part, and the repair is significant. You don't want the person having brought it in and say, well, why do I send it for repair because it can't be had any other way. Why should I be paying due to bringing it back in? I mean, that's
but 6 does not allow for them to pay duty on it. 6 is the exception, I think.
No.
Right, Mr. Edward?
6, right. So 6, the main concern with 6 would be the private persons. Because if you already have a benefit, such as, in a manufacturer, so then it really isn't an issue for you. It's the private person who has a personal item, and for whatever reason, whether it's a choice or because the maintenance services are not available in Jamaica, they need to send that item overseas. And I know when Member Malahoo Ford and Senator Johnson Smith raised the issue, that was their primary concern. Should that person have to pay duties on the watch, on the cost of the repair when the watch is returned to Jamaica?
Yeah, exactly.
I know there were also issues about equipment, right? Other types of equipment, and not necessarily in the manufacturing context, but other type of equipment that may routinely need to be sent overseas for maintenance, servicing. So we're also in the discussion trying to make a distinction between a servicing versus a repair. right? And I remember at one point, the chairman had suggested that perhaps if we deleted the words or placing, there were also issues, then that would perhaps resolve the issue. So now we'd only be talking about maintaining goods in working order, which would, I think, was an effort to limit the provision to only apply to servicing situations. But again, I think when one looks at it, I'm not sure if you can see a clear distinction between subclause 6 and subclause 5. Because I don't believe the manufacturers will have a major issue here, right? Or even the hotelier. So I guess it's possible. But the private citizen who's sending something out for whatever reason, and who's not otherwise entitled to anything.
Yeah, through you, Mr. Chairman. So, Ms. Edwards, what would be helpful for me, I know it happens as our colleague from the custom agency said, Marlon, no, very infrequently, but if somebody can just give me an example of something that that would be caught under clause 6. That's what I'm trying to, I know we said private citizens, but I'm trying to figure out like what. If I can relate to, if I can relate to something from a practical point of view, then maybe I can contribute a little better.
It could be a camera, for example, that is being taken out by someone to come back in.
Okay, but and that's the only reason why they would do that is because it can't be done in Jamaica.
I don't know if I can necessarily say that.
Should we have a de minimis thing that, you know? So yeah, the principle is, you know, a good or a service. We shouldn't discriminate between a good or a service. If you purchase a camera and it's above a particular value, you pay duty on it if you bring it in.
Yes.
If you purchase a service on the camera, so why not just introduce a de minimis? If it's a repair bill, that's, you know, the de minimis threshold today is what again?
$50, Minister.
No man,
that's 500.
The duty, no, because the 50 would apply, not the 500 what people walking.
500 is the passenger allowance.
Yes.
No.
Oh, the passenger allowance, right?
Right.
Yes.
The minimis
$50 is the de minimis.
Right.
So if the repair bill comes in and it's under $50, there'll be no duties.
Right.
I guess if you're sending a high-tech camera overseas, it's going to be over 50.
Mm-hmm. All right.
But also remember, if it's under warranty, then and there's no cost to them, they don't pay.
Right, but we have a specific provision that deals with the warranty already. So we have dealt with the warranty at subclause 7, right? So if it's under warranty, no duties and taxes.
But are you saying now that they're paying duty now anyway, that private citizen? That's what we're saying, right? They're paying it now anyway. So basically what we're saying, if we leave clause 6, there will be no change to what is happening now. That's what we're saying?
No, clause 6 is intended to change the current position. So if clause 6 is retained, so clause 6 will be a new provision that will be inserted.
Yeah, you don't. Go ahead, sorry.
Right, clause 6 is intended to prevent the person from paying the duties on the cost of the repair.
But they're paying it now.
They are paying it now. And clause 6 is intended to ensure that that does not continue.
Okay.
But the revenue at stake is minimal because it's
very minimal. Yeah, because it happens infrequently.
Yeah, but it might cause a lot of harassment. Okay,
yeah, because,
let me ask you 2 questions. Suppose we leave it as it is. If an industry develops that leads to distortions, we can always re-legislate it. Is any violence, is any harm caused? Yeah, so
the risk is that that the treasury might be losing some revenue if something develops. That's what we're saying.
Yes, but we're saying right now, it's not like there's
It's going to be minimal.
right now it's minimal.
Yeah,
There's
yeah,
beauty
yeah.
on it, but it's minimal now. There's not much of overseas repairs that happens.
Yeah, well, that might be a good narrative we can put behind that too.
Yeah, and what we want is for equipment to be serviceable and higher standard, because we want.
Yeah, and then, you know, I mean, the example that you could probably use is the creative arts, you know, because you have some equipment musically that would probably need to go overseas. I know about that.
Right.
So yeah, I guess if the revenue is going to be minimal, there is no harm in my.
It's in the bill table, you know, the table bill has it in there.
Yes, that's what I'm saying. So, I mean, so where my head is now, Chair, is to just leave clause 6 in there.
Just leave it in there. I think that's what Minister Dunn has been saying all along.
That's what I've been saying, yes.
Yeah.
So in leaving clause 6, we're changing the status quo.
That's what we tabled. That's what went through. This bill has been around for 3 years and it survived all the way to Parliament. It's in there. So we're saying, the committee is saying leave it as it is.
Yeah, and the truth is, in terms of some of these cameras and things that go overseas and come back, it's so hard to determine anyway to capture revenue from them. You know, so I'm with you, Minister Dunn. I would support leaving it in with our eyes wide open what that risk is.
Minister, if I may, and I heard what is being said by Senator Webby. There's one issue though, and it's the line that you draw between repair and a complete makeover of an item, in terms of, say, a camera, for example, whether or not it was just a repair or what you're getting back is a new camera.
It's very clear. It says repair for the purpose of maintaining.
Right, and the issue is, how do you now determine that as an officer on the line? How do you determine that that is not, you're not just seeing a new camera with the same serial number as opposed to a part being changed on a camera? And that was part of a discussion we had internally. So when with that provision, there's a difficulty now in terms of monitoring what is maintenance, what is repair from what is a complete makeover, which is another risk. But
let me ask you a question. For the person to be able to establish that this was exported from Jamaica, presumably there's some procedure that it has to be notified that this originated in Jamaica. I'm exporting it now. I intend to import it back. Correct?
That's right. So you'd have looked at the item when it
is looked at the item.
But I make it, which is why I use a point of just the same serial number, because you'd have noted a serial number and all of that, but it could be substantially a different item because you're sending it out.
Yeah, and I'm saying it may not be worth I admit that possibility, but yeah, given the low frequency of persons sending items over for repair, 1, and 2, given the suboptimality of disincentivizing because that need to have functional equipment to produce, that the greater good might be served of leaving it as it is, even if it means that we may err on the side of counting something as a repair, which indeed is a makeover.
Okay. Well said, Chairman. Well said.
Meaning that it's a balance. It's a balance, and we admit that we don't. The cost of getting it right all the time may not be.
And there's a facilitation factor and an harassment factor that you don't need to get it caught.
Okay, I'll leave it there, Minister. Sure.
Just leave it there. Let's see how. I think we give our commitment that to the extent that we have the power to do so, if this becomes a problem, we will address it and change it.
Sure, no problem.
All right. Let's move on. 168 to 171. You want to narrate that, please, Edwards?
I'm sorry, if I could just ask for that one to be deferred as well, just for us to get that language from CPC.
All right, so go for the next one. 177.3.
Yeah, so that one was agreed, Minister, which had to do with the language of justifiable cause. And CPC had made a recommendation. So if I could just, there was an issue raised at clause 204. I'm not sure if it is still live. It was something that was raised very early on by the AG. I'm not sure, she hadn't fully expressed all of the concerns, but she was just wondering whether or not deferment should be mentioned at clause 204. She just asked me to note it, and then she would see if she still had any concerns once we had completed the review. And so I had noted it. But perhaps I don't believe we may not be able to deal with it today. Perhaps when.
Oh, you want to wait on the AG? So we're pushing a lot of things back to next meeting, man. All right, 210 to 217.
Yes, the concerns there, Minister, had surrounded particularly clause 213. And the powers in relation dealing with garnishment. And at clause 213, subclause 6, paragraph B, there had been reference to, in the case of personal service, in addition to any other lawful means of service, shall be deemed to be validly served if left with an adult person employed at the place of business of the addressee. I believe law reform had indicated that it would wish an opportunity to review this to ensure that the provision is consistent with the most up-to-date civil procedures.
Right, other types of equipment, and not necessarily in the manufacturing context, but other type of equipment that may routinely need to be sent overseas for servicing. So we're also in the discussion, trying.
Hello?
Yes, Chairman. I was hearing the recording. Right, so I don't know where law reform is in relation to that, but they had raised some concerns as to the provision there for personal service. And it would also affect clause 213, subclause 7B.
Okay, and what? 213.
Right, I believe that they were just a review to say whether they were satisfied that the provisions there are consistent with most up-to-date rules of word, or whether they had any concerns.
They who were to say that?
As in law reform. I'm sorry, law reform.
Have they come
law
back?
Reform. Law reform has no.
Have they come back to you?
No.
Well, they have to come back by the next meeting. I mean, what are we going to do? Are we?
An expressive follow-up.
Are we at their mercy?
They just need to respond, Minister. Someone need to follow up and get a response.
We will do some further follow-ups, and I suspect something similar for 218 as well. I'm not sure I see Mr. Foreman on, because I know that he had raised some concerns regarding the power of search. This is at clause 218, the power to search under warrants, and he had raised concerns as to whether it will be necessary to insert provisions treating with legal professional privileges, and in particular having regard to more recent case law. Right, so to assess the provision in light of more recent case law to see whether there are any adjustments that would be required.
I can report on this now, Chairman.
Please go ahead.
Right, so we thank you, Ms. Edwards, for that accurate summary of the position. So we reviewed the case that that was mentioned at the last sitting, the emerging principle appears to be that the courts want to ensure that where there are search and seizure powers that have the potential of affecting documents to which legal professional privilege may apply, that the legislative framework should provide some effective protection for those types of documents. So that what we propose is to perhaps add a clause to this section that is in line with what was done in relation to the National Identification and Registration Bill, the NINS legislation, which was also implicated by the case. So during the development of that bill, we had, well, not us, I think the CPC had provided language to the effect that a warrant that's issued pursuant to the powers of search and seizure should include directions as the justice or the parish court judge considers appropriate for handling items subject to legal professional privilege, and as well a provision to make clear that none of these powers should be construed in any way as affecting anything that is subject to legal professional privilege. So that essentially what we want to do is to make express what we would expect would apply in practice, which is that a justice or a judge would in their statements expressly provide for protections for those types of documents, but out of an abundance of caution and in line with where the courts appear to be going, we recommend that those two clauses be added somewhere in the bill. And
so can you give us exactly what you want? You'll email the wording that you want you suggest to be added?
Well, I don't have to. As CPC, I think Ms. Grant is also the drafter for the NINS legislation, and clause 29 of the bill, the one that's now before the Parliament, has language that I just addressed. So if the committee accepts the recommendation, I trust that the Parliamentary Counsel's office will know what to include.
Okay. Any question? Any question for Mr. Foreman on that?
I agree. It's long, but I agree where it's going, the suggestion that he's making.
Okay. All right, so we'll take that suggestion on board and expect the Parliamentary Council to follow through on that. Next would be, is it clause 231? Am I correct there, or is it 231, correct? Ms. Edwards, are you there?
Yes. Minister Chairman, are you able to hear me? I'm having difficulties with my internet. You hear me? Okay. All right. Yes. So yes. So at clause 231, Minister, you had indicated that you need to be guided by the agency or the legal reform department, because that had to do with someone who has been arrested and who has absconded, and the fact that that person would not be liable to be rearrested if 7 years had passed. As you had accurately pointed out, this is a provision that operates in the current act. So let me to read the provision for clarity. Clause 231, will be subclause 2. It says, if a person arrested or liable to be arrested under a customs law escapes from or evades such arrest, that person may be arrested by an officer at any time within 7 years after the date on which the person was first arrested or liable to be arrested, as the case may be under the customs law. Right? So we had some concerns that it meant that if a person, absconds and evades arrest, then, the person would then just have to wait out, and then 8 years have passed, and then he reappears and would no longer be liable to being arrested. But as you pointed out, this is a provision that is in the current Customs Act. And so you expressed concerns with removing the provision, considering that it now exists unless you receive some guidance from the AGC or the legal reform department.
Yeah, no, I still stand by that position. I wouldn't want to take that out unless.
I don't want to change it.
Yeah, unless I got a legal advice that that's not something that I think we should be tampering with. That's for another department of government altogether. Unless, you know, AGC comes back on it. So 235. Can you take
Yes, yes. I don't remember Don still has this concern. It had related to the use of the word commission, but I believe we discussed it.
No, you did, Ms. Edwards,
yes,
you did.
Very well.
Okay, 237.
Right, well, 237 was just a general observation. I mean, there were some concerns there about typos and things that should go back to the margin. And the CPC had indicated that should be going through and tidying those up. And we have also been liaising with her to tidy some of those up. So I suspect we can just treat those as technical edits. And the same thing with 249.
And then 249.
And then that will be it, Minister, because we had agreed on 250 as well, that the word commissioner would replace the word commission in that provision.
That would be it if we didn't defer the deferrals.
No, Minister, I must admit I did not anticipate us completing all of this. There are a few issues that remain in relation to the second schedule. And regrettably, I do not yet have final instructions on those. Mm-hmm. There was also an issue that Senator Johnson Smith raised about contingent rights, you may recall, mm-hmm. and how that is to be addressed. And so the review on that is quite advanced. The member of our team who's dealing with that matter and who has been, not just in terms of representing customs and doing the consultations between JCA, Ministry of Finance and Ministry of Foreign Affairs, but also engaging at the regional level on the issue. She is in the meeting today, but there is still some final matters to be determined, dear Minister. I anticipate that by the next meeting, I will have those instructions so as to determine what to propose in terms of what adjustments may be needed to the second schedule in order to treat with that issue of contingent rights. And in particular, Chairman, just to indicate that what I'm talking about there has to do with the provisions in the second schedule that touch on concern tools of trade.
Right. Understood. Hello? Hello?
I think we have lost
our Minister.
Okay. All right. Well, I think we've done as much as we can do today. We deferred about 10 items. Some items we need to hear from law reform, some items from CPC, and some items, as Ms. Edwards was just describing, the JCA has to follow up with other departments of government. That might mean that we want to probably set the next meeting at a date that would give the best possibility for all of these matters to be addressed, so that if we're fortunate, the next meeting, we could be closing in on wrapping up. Is there any other business that anybody wants to propose that we undertake?
Minister?
Yes.
Madam Chair, there are some matters, I think Hazel alluded to some of them in terms of the review of the schedules to the section, to the customs bill, I should say. And we have done some research, but we have not completed the research to present it to you before it comes to the committee. So we'll have to have further review there, because in terms of some parts of the schedule, there are some duplications that are there. that we are trying to identify and have the CPC remove them. And there are some sections that require a little bit more clarification. And in terms of the consultation with other stakeholders, such as the Ministry of Tourism on the MICE matter, because they had indicated they had a concern with our use of the term consumption. So we're trying to clarify, we're trying to have CPC provide us with proper wording in the provision to treat with those. So for the next meeting, you should be able to, we would have a small presentation to be included in what is to be presented by the JCA. And you will see a document coming to you before then on those.
Okay. So somebody was saying something? All right, it's going to be important that we get all this done by the next meeting. And we had a meeting scheduled for the 14th of October and another one on the 28th, but given the volume, it might make sense to cancel the one on the 14th and shoot for the 28th, by which all of these outstanding matters you should have made sufficient progress on to allow the committee to deliberate. Sounds fair?
Yes, Minister.
All right. Well, I think we've made excellent progress. We are in a very good place. We are at the very end of this process of review of this momentous piece of legislation. I want to thank everybody for your endurance. Right? And we will, oh, you're back. Hazel is back. Okay.
Yes.
And for the standard of the contributions and of the debate and discussions, I think we're making a good bill better, which is what the committee's purpose is. So the date of the next meeting, I would propose to be the 28th of October, which is 3 weeks from today. And 3 weeks should be ample time. I'll just repeat it because Ms. Edwards wasn't on. Should be ample time for all the outstanding matters to be dealt with, including the ones that we deferred today. All of the consultations with law reform, with AGC, with Ministry of Foreign Affairs, and Ministry of Finance, and with me in my capacity as minister, the one or two things that you might want to consult on, all of those need to take place in the next 3 weeks so the committee can consider these final matters and bring the deliberations of a committee to a close so that we can work now on the report that the committee will send to the House. So the 28th of October, is that generally acceptable?
Are we looking at 2 p.m. as usual, correct?
2 p.m. as usual, yes. And
yes.
I get you out of here by 5 o'clock. We've been faithful to that. Well, with that, okay, great. With that, we're at the end of the meeting. May I have a proposal for an adjournment? Senator,
so move, Chairman.
Thank you, Senator Webby. And seconded by Senator Allen. All in favor?
Aye.
Thank you very much.
Okay. Have a good afternoon.
Good afternoon, and see you on Thursday, October 28th.
Okay, take care. Bye-bye.
Take care. Bye-bye.
Let me turn off your video.